Hello, my name is Emma Snape, Special Event and Program Manager for the Maltz Museum of Jewish Heritage. On behalf of everyone at the museum, welcome to our virtual program, DISSENT, Discussion on Election and Voting Rights. This program is inspired by our newest special exhibition, Notorious RBG, The Life and Times of Ruth Bader Ginsburg, presented locally by PNC Bank. I'd like to thank PNC, as well as all of our sponsors and partners, including today's programming partner, the Cleveland Metropolitan Bar Association, who helped make it possible to bring a first-of-its-kind exhibition like this one to Cleveland. The Notorious RBG exhibition is open now, and we're welcoming visitors to join us safely in person, Wednesday through Sunday from 10 a.m. to 5 p.m. We're using best practice protocols such as contactless timed ticketing, wearing masks, and maintaining a social distance to ensure a safe visiting experience for all. And of course, we also welcome you to explore the Notorious RBG from the comfort of your home. On the first and third Tuesday of the month, we offer a virtual online tour of the exhibit at 2 p.m., or you can bring a group for a private online experience. Whichever way you prefer, you can learn more about ways to connect through our website, www.maltzmuseum.org. And I'm so glad you've connected with us already. Thank you for joining us today for the first event in our DISSENT series of programs, in which women in Cleveland's legal and judicial community discuss the lasting impact of some of the late Justice Ginsburg's most notorious dissents. And now, without any further ado, I'd like to welcome Elizabeth Bonham and the Honorable Patricia Blackman to the virtual stage to introduce each other and to kick off today's program. Thank you.
Thank you. Well, I have the pleasure of going first and to also introduce Elizabeth Bonham, attorney at law. And I am just so pleased to be here and to be able to talk to you about Justice Ruth Bader Ginsburg. We have two cases we're going to talk about. That's Bush v. Gore in 2000 and Shelby County versus Holder in 2013. And I have the honor of introducing Elizabeth. Elizabeth is a staff attorney at the ACLU of Cleveland. She has on occasions, and she may not know that I know this, been referred to as the ACLU's secret weapon. After Zoom meetings and talking to her and looking up her background, I am convinced that she has earned her reputation. Her specialty in civil rights and voter rights litigation and all the topics that she's written on, I'm amazed. And I believe she is a secret weapon. She graduated from Wilson College in Chambersburg, Pennsylvania, with a BA in 2011. In 2015, she graduated and earned her Juris Doctorate from Cleveland Marshall College of Law, Cleveland State University. She graduated with honors at both schools. And she also received from Cleveland Marshall the Dean's Learned Law Award, and is only awarded to very, very special individuals. I also found out another bit of information about Elizabeth. In 2017, she was named a member of Crain's Cleveland 20 in their 20s. I was so impressed with that. She is not only concentrating on her, placing her legal talents on civil rights and voters' rights, but is presently working, I believe, Elizabeth, on litigation involving mass incarceration in the United States. I think she understands what Justice Ginsburg understood as well, is that the Constitution is an evolving body of law. Our Constitution is not stationary or a stationary document that cannot be moved. It moves as we move. In her non-legal time, I learned that she's an urban farmer. I didn't know if she knew I was going to talk about that, but she has a wonderful notion about how we feed our citizens in a very humane way. And I'm so proud of her. She is Elizabeth Bonham.
Thank you so much, Judge. It's such an honor to be, well, I guess virtually sitting here next to you, but to have gotten to know you so far. And it truly is my honor to introduce Judge Patricia Blackman, who very recently retired after 30 years serving 5 terms on the 8th District Court of Appeals here in Cuyahoga County, my hometown. So, so honored to be here with you today. You know, Judge Blackman, I'm sure for the audience, needs very little introduction. She has earned many honors, both personal and professional, including introduction into the Ohio Women's Hall of Fame. She's a 1996 Alumna of the Year from Cleveland Marshall College of Law, and has been admitted into the Cleveland Marshall College of Law Hall of Fame Living Legends. In 2018, Cleveland State awarded her an honorary Doctor of Laws. She is the first African-American woman elected to any court of appeals in the state of Ohio, and is here with me to talk about another historic female judge's long career. In 2017, Judge Blackman attended the National Judicial College Mindfulness for Judges conference in Sedona, Arizona. Another thing I've learned about the judge is her interest and expertise in this area. At that conference, she became acquainted with Judge Lee Sinclair, who's a faculty member there, and was invited to present with that person at the National Judicial Institute and Conclave's Emerging Ethics in Today's Cases in Chicago, Illinois, and later on the topic of mindfulness for judges. She has subsequently presented on this topic multiple times, including to judges internationally in the legal community internationally. Starting in April of this year, Judge Blackman will begin teaching a 6-week course called Mindfulness, the Brain-Body Experience as part of this institute. So I'm so excited to have someone with such an expansive mind and such an incredible career talk with me today. It's just a privilege.
Well, I think we should get started. And I am going to introduce Bush v. Gore. So I say to all of you, where were you on December 12th, 2000? If you were a human on this planet living in America, having voted in your respective state, you probably paid attention to Florida, a southern state beautifully designed by ocean water and a gulf, and remarkably tailored by 2 states, Alabama and Mississippi. In 2000, November 7th, it was not a slam dunk for the Republican candidate, President George W. Bush. He was behind in the electoral votes. He only had 246 votes. You need 270. His rival, Al Gore, had 267 electoral votes. You can appreciate how important this is because in America, every state, if you win that state in an election, you get all of the electoral college votes. And Florida had 25. By November 7th, Gore had actually won the popular vote. As we continue to experience in this country, you can win the popular vote and lose the electoral college vote. And that's pretty much designed by how states are represented. So at the end of the election night on November 7th, 2000, it was told to the public that George W. Bush had 1,000 1,784 votes. So clearly he had won the election. At least that's what we thought. Al Gore thought the same thing, so because he called them and conceded the election. Then about 3 a.m. in the morning, I think he found out differently, and everybody did that morning, because the vote total difference between the two was only 600 votes, which entitles you in Florida and in most states, it entitles you to a recount. And this was a machine recount. Now you have to understand and appreciate how many voters in Florida. 6 million voters were tallied in that election. And the difference between the two candidates at that point was 600 votes. So there was a recount, a machine recount. There's also one other factor about Florida you have to appreciate at that time. I don't think it exists now. But at that time, Florida had 4 different voting machines. At the time that the talliation, that they tallied the votes on the recount, it turned out that Bush only had 327 votes, which entitled Gore to another recount. And this was the most interesting recount of them all, because not only do you have the opportunity to have a recount, you can, in a manual recount, you can actually pick the counties you want to have that recount occur in. So you can imagine, the Secretary of State is Katherine Harris, and she's a member of the Bush team. The Attorney General is Butterworth. I think his name is Bobby Butterworth, and he is the campaign manager for Al Gore's campaign. So everybody was ready to go to the Florida Supreme Court, and they did go. And I'm not going to spend a whole lot of time talking about what happened in the Florida Supreme Court, because ultimately the United States Supreme Court took the case. They took the case initially early on, but I won't get into that because a number of the lawyers who are listening probably already understand and know that information. And it's not really germane to what I want to talk about, which is Justice Ginsburg's dissent. So the Supreme Court heard the case, announced that they were going to hear the case on December the 8th, heard the case briefed on December 10th, and then heard oral arguments on December the 11th and issued an opinion on December the 12th. The Supreme Court has never moved that fast. It was a per curiam opinion, which means that it was a unanimous vote. That's what it means to us as judges on the Court of Appeals in the 8th District, and most people who read the definition. But that wasn't the case in this particular situation, because there were 2 issues raised: equal protection and Article 2, which is the Constitution on election of the president. The equal protection argument was a 7-2 vote with Justice Ginsburg dissenting. And then the Article 2 issue was a 5-4 decision with Justice Ginsburg dissenting. I am always fascinated by her and her writing. And so I want, in the brief time that I have, to read a couple of excerpts from her dissent, which I think is just magnificent. She starts out the dissent by saying, "I might join the Chief Justice," and the Chief Justice at that time was William Rehnquist. "I might join the Chief Justice, were it my commission to interpret Florida law." I love that sentence because it gets to the heart of what she felt was so wrong about this decision. She goes on to say, "Unavoidably, this court must sometimes examine state law in order to protect federal rights." But what's the federal right in this case that is at issue? I think she pondered. And then she says, and when we get involved, we, the United States Supreme Court, when we get involved, it warrants extraordinary action by this court. She goes on to say, how power shall be distributed by a state among its governmental organs is commonly, if not always, a question for the state Supreme Court. Now, there are other parts of it, and I'm sure anybody who has read her dissent says that there are a number of things that they would have loved to have me talk about. But I am going to skip to the last two paragraphs in her dissent because they get to the heart of the case. First of all, she points out that the dates that the majority opinion seem to be concerned about, December 12th, when the Electoral College has to convene, December 18th, when they have to meet and make their vote, December 27th, those are dates that Congress has set forth. But the most important date, as Justice Ginsburg points out, is not December, it's January 6th, because that's the date that the Congress must validate those electoral votes. And then she ends with this magnificent statement. In sum, she says, the court's conclusion that a constitutionally adequate recount is impractical is a prophecy. The court's own judgment would not allow to be tested. That bears repeating. The court's conclusion that a constitutionally adequate recount is impractical is a prophecy. The court's own judgment, meaning the Supreme Court's own judgment, would not allow to be tested. And then she ends, such an untested prophecy shall not decide the presidency of the United States. I dissent. And I believe that that was the first time she actually used those words, I dissent. Because as an appellate judge, as we are trained, generally what we would do is say, I respectfully dissent. If you look at any of the dissenters in these cases, that's what they said, I respectfully dissent. But I think, and this is just my opinion, so please do not say that Justice Ginsburg believes this, but I came to the conclusion that what she was saying is, I dissent. I cannot respect an opinion that is not true to the law. And as far as I'm concerned, I dissent. Thank you.
Thank you, Judge. Now I am already getting excited for our talk about these opinions 13 years apart. It's now mine to discuss Shelby County versus Holder, an Obama era case. In this case, 5-4 opinion by the Supreme Court, Chief Justice Roberts writing, and of course, Ruth Bader Ginsburg dissenting. This is a case where the United States Supreme Court eviscerated the preclearance requirement of the Voting Rights Act. In Justice Ginsburg's words, immobilized Section 5 of the Act. So a little bit of background, I know, similar to what people remember they were doing in the Bush-Gore election, everybody knows what the Voting Rights Act is. But just to set the stage a little bit, a brief explanation of its important sections, the sections that are important here. So Section 2 of the Voting Rights Act, I think, is what most people are familiar with. It provides the federal government or the people an opportunity to sue a jurisdiction that is interfering with voting rights on the basis of race. This is a 1960s piece of civil rights legislation. It's major. It's been functioning, and in fact, it's been expanded from the 1960s all the way up through the Shelby County decision in which it gets severely retracted. So section 2 is the litigation section. Section 4 and 5 are at issue in the Shelby County case. In section 4 of the Voting Rights Act, there's an algorithm or an equation that Congress has set out to determine which jurisdictions, and these can be states or counties or smaller jurisdictions, in the past have been particularly egregious in their restrictions on minority voting rights. And using this formula that Section 4 creates, the Act then says in Section 5, the jurisdictions that have been the very worst, that have this long history of restricting the vote for Black Americans and other minorities, if those jurisdictions want to make changes to their voting laws, they have to come and pre-clear it with the federal government. And as everybody knows, this is very unusual. And as the majority opinion relies on, this is a very unusual intrusion into our usual federalist system, that the states would have to pre-clear elections laws with the federal government. And as the majority argues, it's an intrusion into the equal sovereignty of the states because it treats some states differently than others. Well, at the time the Voting Rights Act was passed, obviously there was a very good reason for that, because you could identify states, including the state of Alabama, where Shelby County is, that have time and time again have a long and established history of the most egregious restrictions on the Black vote in America. So Congress amassed data on this, and it developed this equation and said, here's what we're going to do. It was upheld in a challenge immediately after the act was passed, and it was upheld time and time again since. The original sections 4 and 5 of the Voting Rights Act had a 5-year sunset provision. And Congress, through the years, renewed those sections because it found that the states that qualified, or the jurisdictions that qualified under Section 4, were in the same position with regard to the risk that they, if left to their own devices, would pass these voting restrictions, these same Jim Crow era voting restrictions. In fact, over the years, the act was expanded, as I mentioned, to include not just restrictions on the basis of race and color, as was the case in the original act, but also on the basis of minority language. So the act was renewed after the 5-year sunset. It was renewed again, and it was renewed with a 25-year provision all the way up until 2006. And after 2006, these jurisdictions, mostly southern states, started to see an avenue towards making a challenge to enjoin these sections of the Voting Rights Act. Shelby County, in the Obama era, sues the Attorney General, Eric Holder, making a facial challenge to both provisions of the act. And the court, Chief Justice Roberts, writing for the majority, says, you're right. The District of Washington, D.C. and the D.C. Circuit both said, Congress has amassed a huge record demonstrating that the preclearance requirement in the Voting Rights Act is still necessary. And the Supreme Court of the United States says, no, you're all wrong. The DC Circuit, the District of DC, and the huge record amassed by Congress, you're all wrong. And here's why. The majority really relies on, as I mentioned, this idea that federalism and that the equal sovereignty of the states prohibits this kind of conduct by Congress without a rational basis. Really, the Chief Justice's rationale here was that since we passed the Voting Rights Act, things have just become so much better for minorities, and things have just become so much better that we don't need the preclearance requirement anymore. So if you look at history, that was then, this is now, and not addressing the pieces of the record that that undermine that position, the court says, we don't need this anymore. America has moved past this day. Strikes down on a facial challenge this provision of the act. That's Section 4, but effectively immobilizes also Section 5. And Ruth Bader Ginsburg dissents. And what I want to talk about with regard to her dissent are a couple of things. First, how she situates us in history. You know, the dissent is longer than the majority opinion here. Justice Thomas concurs, by the way, only with the majority only to write that even more civil rights should be infringed upon. Justice Ginsburg dissenting says, okay, let's if we want to talk about the past and the present, let's situate ourselves between the enactment of the Civil War amendments in the Constitution and the passing of the Voting Rights Act was a century of voter suppression. And during that century, we tried it your way. You know, she says to the majority, we tried litigation and we tried advocacy. And each time we tried to strike down some form of voter suppression. And the justice refers to this as battling Hydra. The states at issue here, these jurisdictions, would just come up with another one. It's time consuming and it doesn't work. And the time between this Voting Rights Act passage, the renewal of these provisions by Congress is a much shorter time period than the century preceding. And Congress found through research and testing that, in fact, these provisions are still relevant, are still needed, both to create a deterrent, you know, to prevent backsliding, and affirmatively needed because these jurisdictions had tried many, many times to pass voter suppression laws that the federal government wouldn't pre-clear. So first, Justice Ginsburg situates us in that history. And the other thing she does that I wanted to mention that I think really talks to the Bush versus Gore dissent is she identifies the inconsistency in the majority's opinion that it uses to reach its desired result. You know, Justice Ginsburg says, wait a second. The majority is so quick to reach its result, it doesn't even identify a standard of review that it's using. And if it had, we should be using rational basis review. This court would uphold anything on rational basis review. And here it's looking at an extremely well-developed record and it's saying that's not good enough. And typically, obviously, in these kinds of issues, if you're looking at an ends means test, what you want is for the government to prove up that it tried other things and failed. And that's what they've done here. So in theory, it should survive an even more stringent standard of review. So you didn't do that. Then she says, hold on, this is a facial challenge to an act of Congress. And you're ready to just accept that this is appropriate to entertain a facial challenge? Well, you don't really usually do that either. And in this way, this is something that I love the most about her dissents. And I think she does this similarly in Bush versus Gore. You know, the court doesn't usually do this, and sort of indicating it must really want to get to its desired result here. And in that way, it's being really disingenuous with its jurisdictional precedent. At the end of the dissent in this case, she doesn't use the now famous words, I dissent. She says, I would affirm the decision of the Court of Appeals. And I think, again, you know, she hasn't said this explicitly, but for me, what that says is, you know, everyone who has looked at this record genuinely, thoroughly agrees with me. And you know, you all have a result you're trying to reach, and it doesn't respect the record. So I'll stop so we can have a talk.
Thank you both. Those are such fascinating explanations on the history of these cases and on the dissents. And I also cannot wait to get into the questions that our audience has been sending in and that we prepared in advance. As a reminder to folks watching at home, you can continue to send your questions in for Elizabeth and for Judge Blackman through either the chat by sending them to all panelists and attendees, or by using the Q&A feature. So to kick off our conversation today, I wanted to ask the two of you, first of all, what motivated you to choose this topic for the DISSENT series? There were a couple of different options that you could have chosen, and you both were drawn to voting and election rights. Could you tell us a little bit about why?
Elizabeth?
Sure. I think for me, this is just, and the court says this, and I think Ginsburg in most of her voting rights work says this, this is the area from which all other rights flow, the right to the ballot. And so for me, this is just, it's so critical, it's so foundational. It's something I have a real passion for, and something that the ACLU has done a little bit of work on. My boss has done an incredible amount of work on, and got me interested in as a litigation matter. But also, more broadly, it's just the foundation from which everything else flows.
How about you, Judge Blackman?
Well, when I looked at the list, there were a number, most of the lawyers on the list I knew. I'd never met Elizabeth, but I have followed her, and especially in the Crane's article, and so I wanted to meet her. And I thought, what an excellent way to meet someone who is traveling down the path I wish I had stayed on. And when I initially, I am a child of the South. I came from Mississippi. I came here to go to law school, and I was just going back to Mississippi to practice. And I wanted to do civil rights litigation. And I ended up staying here, and my life is an open book from that. But those two things motivated me. And I actually teach the Bush v. Gore case in my class at BW. It is the Institute for Learning and Retirement, and these are senior citizens who want to continue to learn. And so I teach this case, and every year it's a different kind of feeling about it. And every time I read, which is what prompted me to do this today, is to forget about talking about what the Supreme Court did, because we pretty much know that they ruled in Bush's favor because he became the president. He got the 25 votes and he won from that standpoint. But the one thing I always keep finding out from my students is that there's something else that's missing. And one of the questions that they will always ask is, how did they come up with the 527 votes that they attributed to Bush? Because it never happened. Initially it was 327 was the difference between the two candidates, but yet Bush was given 537 votes when they certified the election. And that's one of the things, is that it's always something fascinating about the case that comes up. So if that makes any sense, those are my reasons.
That absolutely does make sense. And that actually brings up one of the questions from our audience that I'd like to jump ahead to, if it's okay with the two of you, because It's specifically about Bush v. Gore. But so you've been asked, do we know anything about the deliberations of the decision in the Bush-Gore case? Could there have been an explanation not involving politics, but rather strict constructionism, loose construction, or judicial construction?
Well, not to my knowledge, and I've researched it. I haven't done extensive research on it, but in the sense that I've read the case and I've tried to listen to every commentator on it. And just recently, I think the two lawyers celebrated the anniversary by talking at Harvard on the case. And no one seems to know but is a fascinating piece that I left out. And the lawyers will correct me who are in the audience if I'm wrong about this. But I think that the Supreme Court initially issued to the first Florida case, they sent it back in a 9-0. And in that opinion, they were saying to the Florida court, we don't know what you're talking about. And on that case, all the justices agreed. Then things just got out of hand because they were filing lawsuits everywhere. And then eventually we get back to the Supreme Court on 12-8. I don't think that the Supreme Court actually, I think they had a conference and they pretty much knew what they were doing. They had a 7-2 on the equal protection issue. And even the lawyers say that the equal protection issue was not really their main focus. The main focus was the Article 2 issue, saying that we really need to move this fast, and the counties are not counting the votes fast enough. One county, Miami-Dade, just threw up his hands and said, we're done. We can't finish this. It's too much. And so when you were having this, and then you had all the hanging chads and the pregnant chads and the butterfly ballots, and all of those things were interplaying. And so I think that after the oral arguments, if you ever get a chance to listen to the oral arguments, it's actually Justice Kennedy that keeps taking everybody back to equal protection, as if the ballots have some weight. If we let the count go forward, then there's a discrepancy, there's unequal treatment of one ballot over another, which is the most fascinating thing to say without proof of, because they had stopped the counting. So how do you know what would have happened? And I think that's why Justice Ginsburg's last paragraph is so telling. She says they have this prophecy that they can't get it done, but they won't even wait. And my reading showed that they had stopped the counting on December 1st of the manual counting, that they had issued a stay order. And therefore, if they had let it go through, then we would know. And that's what she's saying. Why not see what the answer is? And then if they have some challenges to how it came about, if it's too long, does it violate? And we would get back to the standard of review in terms of, is it too long if you go past December 12th? It's probably not too long. And so there's no rational reason to disregard the Florida law. So in answer to the question, I don't believe they conferenced much because they all kind of knew. I think Justice Ginsburg refers to the 5 conservative justices at the time as the usual suspects. And then the 4 of them, the liberals, as the usual suspects also. They kind of knew what they were doing. They just didn't know that they were going to get Souter and Justice Bayer on the 7-2 decision with respect to the equal protection. But Justice Stevens' dissent just destroys that whole equal protection argument. It's not. So I hope that at least sort of answers the question.
Absolutely.
Because quite frankly, we really just don't know. And nobody seems to be talking. So there's no tell-all book on this. Yeah.
The mysteries will have to continue, I guess. Elizabeth, is there anything you'd like to add in answer to that question, or should we move on and take the next?
You know, I just think in terms of the question was couched as sort of an explanation not involving politics, but involving something else. From my perspective, I don't have a lot of faith that you can altogether keep politics out of it. I think some people would strenuously disagree with me on that, but saying something that a decision like this is totally apolitical, I think I would have a little bit of trouble with that. You know, one of the things Ginsburg says in the dissent, she accuses the majority of legislating this result in the place of the Florida laws. You know, and I think for me, it's just this kind of intervention is extraordinary. Intervention by the U.S. Supreme Court is extraordinary. And I think, I guess it's no secret, I think it was the wrong choice.
And it's extraordinary in this sense, because first of all, it had never been done before. And these were the state rights judges. They were the ones who were always ruling in favor of the state's prerogative to do what it did. And so Florida has all these laws. It's their law that allows for this. And I think on a rational basis analysis, one could say that as long as you don't impede on the January 6th date, you're in good shape. I don't think you're gonna, and I think that's what Justice Ginsburg is saying. She's saying, why, let them count the vote. You have 1,000 votes out there that people are being disenfranchised over, and you're worried about whether there's some balance between ballots. And it just made no sense for her.
Fantastic, thank you. Why don't we zoom out a little bit to the work of Justice Ginsburg a little bit more broadly? And so in each of your opinions, how would you say that Ruth Bader Ginsburg used her dissents and the ability to dissent in order to impact voting rights over the course of her career?
You know, I thought about this a lot, and I'm not sure that I'm the right person to answer. I think Elizabeth probably has a little more information about it. But I was just thinking that I'm not so sure that her dissents has impacted voting rights over the years. But I think in the coming years, because of what's happening with access, and I think that's the key, we have not made the distinction between the right to vote and access to the ballot. And so a number of states are trying this approach of denying you access. And then ultimately what they're doing is denying you the right to vote. And what the 15th Amendment is pretty clear. No one has ever raised that issue, but it's pretty clear. It says you have a right to vote. And it doesn't say you have a right to vote if you move to across the street or if you move to another block, or it's just pretty clear. And I think her dissents are going to just magnify how we approach these new issues that are coming up.
Thank you.
Yeah, you know, I agree with you, Judge. I think for me, it's a sad question. Why is Ruth Bader Ginsburg famous for her dissents? I don't want somebody on my team that's famous for their dissents, you know, but it's such as it's always been. Thurgood Marshall, the famous dissents. You know, right now in the election litigation over the pandemic and other litigation during the pandemic, people being deprived of their rights. On the Sixth Circuit, Judge Karen Nelson Moore has a dissent for that. You know, that's those things are important. They're important, I think, for our future, as you said, Judge. For me, they're important because they're at least an articulation of how things should have been. They don't allow us to forget or to mistake how things should have been, what the record actually is, what would have occurred if the majority were intellectually honest and consistent in its application of the law. So in that way, it anchors us in reality. It shows us what a better reality could look like. It documents the facts in a very powerful voice. And I hope that it'll be our guidepost for the future.
Thank you. What a really thoughtful answer. We talked a lot about dissents and the role of dissents and whether or not we were content with them in the initial conversation that the three of us had. And Elizabeth, I really appreciated what you just said right now about you not wanting that to be the person on your team. You want to have the majority opinion. And so Judge Blackmun, I was wondering, could you weigh in a little bit on that? What do you think about the role of a dissent today?
Well, when I first went on the bench at the 8th District, I dissented a lot. And I never thought I was dissenting for posterity, but I always thought that the minority voice needed a platform. And if the minority voice doesn't have a platform, then you don't know. And that goes to Elizabeth's representation about perspective, putting it in perspective and helping us to see how the law actually was at that particular time. And I go back to Plessy versus Ferguson or the Dred Scott decision, where you had one lone dissenter in those horrible cases. And then we had all of this struggle, and it took like 90 some years before we get to the Voting Rights Act of 1965. That is so easy to just dismiss. And so I look at dissents in a different way. I think we need a platform. The minority needs, there were several dissents that I've written about the Fourth Amendment. I think that it has been gutted and pretty much destroyed, and it doesn't exist anymore. And I don't agree with justices who think, well, we don't really need the Fourth Amendment anymore. As they said, we don't need the Voting Rights Act anymore. And I'm always taken aback that Justice Roberts was the one who wrote the majority in Holder. He was also an advisor to Reagan when the Civil Rights Act came up, when the Voting Rights Act came up. And he advised Reagan not to sign it. So I guess even back then, he was thinking that we've done this enough. Black people, people of color, people who are disenfranchised, that they have enough. It's yours, as Clarence Thomas would say, it's your responsibility to go out and find your vote, as opposed to somebody delivering it to you. I think is what he's talking about. And so that's my position.
Thank you. Judge Blackman, that actually ties in really well to a question that we just got in from our audience, specifically for you, though Elizabeth, I would love it if you also wanted to weigh in on this. But Judge Blackman, you are being asked, so a member of our audience says, I am also a child of the South and old enough to be in your seniors institute class. I moved north to Cleveland to escape the insanity Florida has become, and now I'm watching in horror as Jim Crow is being resurrected state by state. How can we in the civil polity take a proactive stand against these acts to, in quotes, whitewash the vote? Is there anything that you can advise from your experience, or Elizabeth, from your work with the ACLU, about what everyday citizens can do?
Well, first of all, I love that question. And I think that we cannot close our eyes. Things have not changed. If you look at Alabama, how many times, and Elizabeth can help us with this, how many times did they try to get a law passed that was designed to suppress the vote, not enhance the vote? I mean, the right to vote should be easy, not complicated. And it gets made complicated because of politics. If I remember correctly, in Canada, everybody can mail in their vote. Even the president of the United States can mail in his vote, but yet the mail-in vote issue is being challenged because of what happened during the pandemic. And I think we ought to just sort of look at the good news of the pandemic. We had more people vote in this country than ever before in the history because they could vote by mail. They could drive downtown and put it in a box, and they didn't have to go through anything. And we, just face it, we kind of like easy things. We don't really want complicated things. And so when I look at it, I say, stay vigilant, don't close your eyes, don't pretend like it doesn't exist. And one of the things that, and Elizabeth is probably gonna not agree with me on this, but one of the things I thought about for a long time when Houston was throwing people off the rolls, because I also teach that case to my students. And I was like, okay, what are we going to do about this? We have a computer system now that can identify everybody. So if you have 1 million people who have been thrown off the rolls, you should know how to get in touch with that 1 million people. And you should start sending them notes, telling them, because the state's not doing it, telling them where they can go, who they need to sign up with. And if we have to pay for it, then we have to pay for it. But it is the fight. it's a fight that we will just have forever because it's politics. And it's unfortunate. But if you look at, I mean, historically, I go back to the first vote. The first voting used to take place outside in parks, and people could see who you were voting for, and then it was a riot because they'd start fighting, and so they went indoors. So there's a lot of things that we have to deal with as humans. But I think we have to stay focused and not let anybody tell us that, oh, everything's over. You know, these people have the right to vote. Why aren't they responsible enough to just go get the right to vote?
That message of vigilance that's right on for me. You know, I think it's recognizing that this is a system feature, not a bug. Voter suppression. It's always been there. They've been doing it as long as they possibly could. And they've mostly been doing it to Black people. And that has not changed. It just hasn't changed at all. And you can prove that up. And any counter argument, you just can't prove it up that you hear. You know, there's going to be massive voter fraud. That's not true. There's not massive voter fraud. Even if there was massive voter fraud, would that be more important than getting people their right to vote in the first instance? You know, these counter arguments for me really fail if you are a person who's invested in a democratic society. And we've seen this coordinated effort to suppress the vote over and over again. We've seen it here at home in the last year, just abundantly. You know, how can we make it easier for the people to vote? Can you send them an application to vote by mail? No, massive voter fraud. Can we expand the locations of where mail drop boxes are so people can drive up? No, massive voter fraud. There's a case coming up to in front of the United States Supreme Court right now. You know, what about, can we have people who need to pass their vote off to a neighbor to get it across a long, you know, a really burdensome journey to get to the post? No, that'll be a felony, massive voter fraud. And we have decisions coming down from our federal courts, coming down recently from the Sixth Circuit, saying things like, you know, the right to vote in our society, it's pretty good. So you should be satisfied with that. We're making that assumption, the federal court's making that assumption, even though the record belies it. And, you know, suck it up and deal with it. Like you said, Judge, go get your right to vote. Well, for me, that's not what a democratic system of government should look like. And I think if you proceed from that premise, you would agree that the vote should be, access to the vote should be as liberal as possible, as widespread as possible. And I think if you don't think that, you must be proceeding from a different premise, that only certain people should really have the right to make the policy that this country uses. So I think staying vigilant, I think recognizing and saying for others that this is happening, and that there's no explanation to justify it, and that we should all be invested in eliminating this kind of voter suppression.
Oh, sorry.
No, I'm sorry.
I didn't mean to interrupt, because I thought maybe I had a question for you, Elizabeth. Maybe she could help us have an appreciation for this. What is the evidence? Everybody is allowed to throw these words around, but what is the evidence of massive voter fraud? What does that even mean? And if it is massive voter fraud, wouldn't the Board of Election know? Wouldn't the Secretary of State know? They're empowered with the authority now with computers to be able to determine any number of things. That's how they can throw people off the rolls. They can go in and see that you have not voted in a couple of years. Boop, you're off the rolls because you obviously are dead or don't want to vote. So if it's massive voter fraud, it ought to be some body of evidence, and they ought to be required to come into court and prove it. and not just say it, because to me, there's no rational basis for that argument.
I think that's exactly right. You know, I think it's a specter. It should disappear.
Yeah.
That's it. There's no evidence. There are vanishingly few cases of individual voter fraud after investigations, seriously resourced investigations, you know, routinely uncover very few, if any, cases of individual voter fraud. Sometimes on a slightly larger scale, you know, there have been uncovered these party level vote buying schemes and so on and so forth by both parties, you know, and not even close to a sufficient risk to justify such a severe state action as suppressing the vote. Mm-hmm. But really a social scaremongering tool that, you know, litigants and interest groups will just will not stop beating that drum.
Thank you. I would also like to ask, while we're on the subject, another topic that had come up among the three of us in our earlier conversation was gerrymandering and the threat that that currently poses to voting and election rights. For anybody in our audience who might not know as much about gerrymandering as the two of you, I was wondering, could you tell us a little bit about what that was, why we should know about it, and why we should care when we think about voting rights and elections?
Well, this is a subject that I also teach, because I like for my students to understand that there was a man named Jerry Mandering, and he ran for office, and he created this district that looked like a salamander, and so everybody started calling it gerrymandering. And this was I think he was the governor of Massachusetts, and he created this district. And what happens, and I don't think it was widely used as much until the Reagan era. And what I think those attorneys understood was the more districts that we can create, and there are two in Ohio that are kind of bizarre. And one is called the Snake on the Lake, and that's the Marcy Kaptur district. And it runs across, and it actually does look like a snake on the lake. And then there is the one that's down in Columbus area that they created for Jim Jordan. And it looks like a snake as well. So I don't remember all the details. I may have gotten Jerry, the person who came up with this idea a little mixed up, but it is not good. And generally, in terms of population, the Supreme Court has been very clear. But when it comes to partisan gerrymandering, they've not been so clear. It's been kind of slippery, you know. What is partisan gerrymandering? And then the age-old question that comes up is, well, the Democrats do it too. And so when they have an opportunity to set the vote, they do it too. So my answer has always been, we are in an era now where you have computers that are so fascinating. And we have these super techie humans on Earth who can actually, we can get to draw these lines, and you could probably give them a test and they'll say, no, I just like to do this because I love putting these lines together so that individuals, and then we have some true, honest lines drawn. I think so far, I don't know, Elizabeth, correct me if I'm wrong, that the only state that has truly drawn the lines in an equal, in the way that a tech person would do it is in Nebraska. So you live with the consequences of how the vote comes out when the lines are drawn fairly and equally and in a way that, wouldn't it be nice if I could live in a community where they're like-minded people? Maybe that's too much to ask for. I don't know, Elizabeth, what do you think?
You know, I think I do think that's an important distinction to make, so there have been gerrymandering, right, is the drawing of district lines, school board, Congress, whatever district lines to manipulate the vote by packing certain people into certain districts, cracking other districts, splitting jurisdictions, manipulating the voting districts to a particular end. And racist gerrymandering is something that blessedly we can still challenge in the federal courts. And so, this is the drawing of these lines to disenfranchise Black voters. Another voter suppression tool, it's a classic, it's a greatest hit. And you can use Section 2 of the Voting Rights Act to challenge it. In fact, in the Shelby County dissent, when Justice Roberts in the majority is saying how we don't need the Voting Rights Act anymore, Justice Ginsburg in dissent identifies an instance in 2011 where had to be an FBI probe and a criminal trial because there's discussion in Alabama, in an Alabama town, of doing this kind of racial manipulation of the voting districts in order to disfranchise Black people. So this has always occurred, and we should, challenge this. Then, two, partisan gerrymandering occurs. So drawing the districts for a partisan advantage. And like you said, Judge, Democrats do it, Republicans do it, whoever is holding the pencil might do it. But it disenfranchises the minority group in that jurisdiction. And it's been challenged recently, and I'm sure many members of the audience know about this, in a pair of Supreme Court cases that came up, one challenging a Democratic and one challenging a Republican gerrymander in the cases of Benisic and Rousseau. Another instance where I would have liked to be on the side of the dissent, Justice Kagan dissenting in those cases, just like the voter purge case, Justice Breyer dissenting in that case, to try and at least document that these voting rights shouldn't be taken from Americans. But in the Rousseau case, the Supreme Court held, Justice Roberts, again writing for the majority, that whether partisan gerrymandering is appropriate is a political question. It's not the province of the federal courts. And if you'd like to challenge a partisan gerrymander, don't come here. This relates to something I think, again, Justice Ginsburg writes about in the Shelby County dissent. One of the things she identifies is that, of course, if you call it a political question, the people making those rules are those benefiting from the status quo. They have no incentive. In fact, they're disincentivized from erecting barriers to their own misbehavior. And that's why we have the federal courts, to check that misbehavior. But in the case of partisan gerrymandering, we are no longer welcome to seek that kind of check in the federal court system after a couple of years ago. Though in a companion case in Ohio, we proved the what I believe to be the unconstitutionality of the federal district lines on partisan gerrymandering grounds.
Well, I would like to make one correction. I think his name was Elbridge Gerry. And that partisan case that you're talking about is the Gill, and it was written by Chief Justice Roberts. So just thought I'd throw that out.
Fantastic. We have a question from our audience actually about some redistricting here at home in Cuyahoga County with the 11th congressional districting. And so there has been some back and forth with this district in moving it from Summit to Cuyahoga, which would change whether it's a majority minority district. And so our audience member is asking, does the Voting Rights Act require the preservation of majority minority congressional districts where feasible? And would the ACLU take part in such a case to preserve minority voting rights? Elizabeth, do you think you could take a swing at that one for us?
Honestly, I don't know enough to tell you. And I would hope that we would get involved if such a challenge were viable and if such suppression were going on. But I don't know about the present status. I mean, we're going to have to draw another district map at every level, but I don't know about the present status of the census numbers, you know, whether that will be delayed, what the delay will do, and so on. I don't know if you do, Judge.
I think I think it's definitely delayed. And thank goodness it is. And that we have, at least under the Biden administration, some semblance of maybe we can get some accurate numbers before, because what a number of people I think don't appreciate is that this is how federal dollars are sent into your state. And so if you dumb down your numbers in order thinking that you are keeping certain individuals from participating in the democracy, then you're actually hurting yourself. And this is something that we really have to talk about. And I just remember when, I think it was Stephanie Tubbs Jones may have been running for the congressional seat. And there was always this talk that we should create these lines so that we could keep a district where African Americans would have a voice. And I go back and forth on this issue. And I keep thinking that at some point, we have to take politics out of voting. And the way you take politics out of voting is you make the Secretary of State nonpartisan. The Secretary of State should be the one that is leading the road to effective voting and effective lines and understanding how the state should operate. And I think if you do that, then you have a shot at it. There's always going to be greed and corruption because there's some human beings involved in it. And so that comes up. But I think my hope is that at some point we get to a place where there's some fairness involved in it. And if we take politics out of the Secretary of State's office, and we saw that with Jennifer Bruner, you can have fair, equal elections that way. Now, people didn't like the outcome, but at least when she was the Secretary of State, everybody could vote. And that's a good thing.
In closing, I have one last question for the two of you before I let you both go. Thank you for your time and send our audience on their way tonight. But to wrap up our conversation tonight, which I've greatly enjoyed, in your own opinion, how do Ruth Bader Ginsburg's dissents in these two very different cases shape the conversations that you see happening today in 2021 around the subjects of voting rights and fair elections? Would you like to start us off, Judge Blackmun, since Elizabeth started the last question?
I'm not sure that I'm getting the guts of the question, because it seems to me that this came up earlier, but maybe it was just because I was thinking that we were talking about this issue. Could you just phrase the question again, please?
Yeah, for sure, for sure. Okay, so as we look to the future, how do you see the dissents from these two different cases shaping the conversation? And we did touch on this very briefly, but I thought it would be a nice way to close the conversation off just to round it out. So if you could revisit that slightly or add anything that you didn't get a chance to talk on.
I just think that the historical aspect of her dissents actually lay the groundwork for future cases and to give people knowledge and platforms. And I think that's very important. And I just think that her dissents in all the cases that you're going to be exploring are going to set that tone. She does something and has done, she did this in the past. I don't know anyone else other than Scalia who has done it, where they read their dissent from the bench and they do a summary of the dissent. And she did that in the Liddy Ledbetter case. And I think that those dissents, she understood that what she was doing was setting the stage, because people would have to look back at Justice Curtis and Justice Harlan and those dissents in the two most important cases that could have shaped the country into a better country if they had just been listened to. And this is what dissenting can do. And people will go and look at those dissents and see if they can make the same arguments. And I think Elizabeth's group, the ACLU, fabulous in terms of how they represent the issue. They're bright lawyers. They probably need a lot of support from us in our community, and we should take advantage of the opportunity to be supportive. And I think that they will help keep the voice alive as well.
Wonderful. Thank you, Judge.
Thank you, Judge. You know, I think there's very little to add. What she's doing in these dissents is she's saying, here's what happened. Here's what happened in the jurisprudence. And here's what happened in the material history that we're living in. And she's saying, here's the roadmap. You know, when the tides turn, here's how you write your brief. And that's what we'll have to do.
Thank you. Then Judge Blackman, Elizabeth, thank you both so much for such an engaging conversation. I've really enjoyed talking to the two of you
Thank you,
today.
Emma.
Thank you.
And thank you also to our virtual audience for joining us today for this discussion. We were so glad to have you with us. If you'd like to, you can join us again next month for the next installment in the I Dissent series, which will be a discussion on employment practices in the case of Ledbetter and Walmart, with the distinguished attorneys Rosalina M. Finney, Karen Kaminsky, and Roni Sokol. You can find out more information on these programs and others by visiting www.maltzmuseum.org. Thank you again to Elizabeth and to Judge Blackman. Have a wonderful evening, everybody. Thank you.